Very good morning to all my dear students. I am Professor Avriti Tangri from Shree Atam Vallabh Jain College, and today I'm going to discuss with you the characteristics and the nature of the company, which will help you to better understand what company is all about and how it is distinguished from other business organizations. To start up with, let's discuss the meaning of the company first. The company is registered under Companies Act 1956. The act was established in 1956, and since then it has been amended number of times to add new protocols and new rules for the company. Company basically is a body of association of number of people who come together to pool their resources in cash or in kind, and these associations, these resources are then utilized for the company. There are a number of definitions which describe and discuss the meaning of the company, but then Lord Justice Lindley has well explained the company, saying that company is a mode, it is a mode of doing business where number of people come together and pool their resources for a common purpose to a common stock for a common objective, right? So to deeply understand this definition, let us discuss some more things about company. Company basically is a form of organization which is separate from its owners and separate from its managers. There are two bodies. Firstly, we can say a board of director is a body which operates, which controls, and which manages the company, which basically runs the company. It participates and it discusses the day-to-day functions of the company. And the second body is the members of the company, which we can say are the shareholders. जो shareholders होते हैं basically they contribute to the capital of the company. They are the real owners of the company because company do not have its own resources or its own capital. So the company borrows, or you can say the company is being given the capital by the shareholders in the form of shares. The company issues shares to the shareholders. The shareholders purchases the shares of the company. In return of the purchased shares, the company gives the shareholders a share certificate which act as a proof that the company has sold certain number of shares at certain price to their member or the shareholder. In return, the members, they contribute capital to the company. So therefore, company is separate from its members or the shareholders. Company is an artificial person in the eyes of the law. As soon as the company is registered under Companies Act 1956, since then, after its incorporation, the certificate of commencement gives the company a green signal that the company is ready to be operated as a company. And after certificate of commencement and certificate of incorporation, which is given by the government to the company, since we can say that company is now being called artificial person in the eyes of law. The company is now separate from its owners, which we say that they are the members or the shareholders, and the company is separate from the board of directors also, who are the managers, who are just working like agents, or we can say like trustees for the companies. Coming on to the same concept, that the company is separate from its owners and its members, it has a separate legal entity. Company can borrow money in its own name, and company is able to sue other people and be sued by other people in its own name. So for example, if somebody wants to sue Reliance Industries, the case will be filed in the name of Reliance Industries Limited and not on Ambani's. So company has a right or a power or a separate characteristic that it can be sued, and it can be sued also, and it can sue other people on its own name. Similarly, the contracts with the company, all the contracts with the company are obviously have to be on the name of the company and not on the name of any of the shareholders or the members or the board of directors. Any contract, for example the contract of purchasing a building, for example a contract of purchasing raw materials or the machinery or material, the contracts will be on the name of the company and not on the name of the members or the shareholders. It is also said the company has perpetual succession, which means the members may come, members may go, shares are transferable also, but the company go on forever. The company is given a birth through a legal process, which we say is a incorporation of the company, and company is not affected by the death, insolvency, insanity of any of the members or the shareholders or the board of directors. So therefore company has a perpetual succession. It is brought to end also through a legal procedure which is called winding up. So both the birth of the company and the end of the company is through a legal procedure and not by act of any of the human nature or any of the human being. Next important feature is that the company has a limited liability. Unlike a normal business organization, which is a sole proprietor or a partnership, where the liability of the owners are assumed to be the liabilities of the business, and vice versa, that the business liabilities are the liabilities of the owners. The owners have to sometimes give up their personal properties also to pay back the liabilities of the business, because it is sole proprietor, where there is no distinction between the owner and the, you can say, the business. But here in the case of the company, once you have given the share amount, for example, if the share is of rupees 100, then the company cannot demand anything more than rupees 100, because the company has a limited liability characteristic, which explains that the members are having no other liability than to pay for the amount of the shares they have actually agreed to pay. So the share amount, whatever it is the maximum liability the members have to pay, and nothing more than that. Sometimes there is also amount mentioned in the memorandum of association of the company, and that is also limited, which we say that the liability of the members is limited to guarantee. That characteristic is called that liability of the members is limited to guarantee. Guarantee means that whatever has been written in memorandum of association of the company, the members have to pay for that, but nothing more than the guaranteed amount which is already mentioned in the memorandum of association of the company, right? So these are the various characteristics of the company form of organization. And since we are always saying that the company is a separate legal person, it has a separate identity, it is an artificial person capable of making contracts, capable of undertaking any of the agreements, capable of being sued, and capable of suing others. So the company, because it is an artificial person, cannot sign on its own. Therefore it has a common seal which will act as a signature. Common seal is a stamp which is the company uses for affixing its signatures to all the documents, right? So apart from these, company has a characteristic that the shares of the companies are transferable. The shares of the company are freely transferable. And when the process of formation of the company is going on, there are certain important documents which the company need to prepare. The very important document is memorandum of association, the most important document. Memorandum of association has various clauses. For example, it has the name clause, it has the registered office clause, it has the object clause, which explains the status of the company with the outsiders, which explains what the company is all about, which explains about the objectives of the company. And whatever is stated in the memorandum of association, the company is bound to do those activities only, and the company cannot perform any other activity beyond the stated objective. Similarly, the memorandum of association also provides the name of the company, and the name must be in the sovereignty and in the favor of the country, and it may not hurt any religious sentiments of any community or the country. So name must be decided very carefully. And if there is public company and private company, then the private company has to write down the word private limited after they name their company. Similarly, after memorandum, the next important document is articles of association, which describes the internal management of the company. Like memorandum describes the what company is all about, what the company is having relations with the outsiders, how it will perform, what it will perform, who will be the main subscribers to memorandum, The capital clause of the memorandum will tell about the authorized capital, subscribed capital, but articles of association will tell about the internal arrangements of the company. Who are the directors, what are the powers of directors, these will be the contents of the articles. Similarly, the next important document is prospectus of the company. The prospectus basically is a document which will help the outsiders to peep inside the company and to know what company is all about. Prospectus is a window through which we can see inside the company. We can see what the company is doing throughout the year, how the company is performing, which are the areas of operation of the company. So prospectus is basically required in order to sell the shares also, and in order to help the outsiders to know more about the company. All these documents are called the public documents of the company, and they are open for inspection either on the website of the company or at the registered office of the company. So these are the very important documents. So company is a that form of organizations which is going to build future, which is going to nurture the country, which is going to be very useful in increasing the GDPs of the company. So therefore that is all about company. And in the coming videos we will discuss more about company, we will discuss more about companies act, we will discuss about memorandum articles. This was the very brief introduction towards what company is all about. Thank you, all of you.